Hello, everyone, and welcome to the AIPPI Standard and Patents Committee's first webinar of the year. Today, we will be discussing an international update on courts and interim FRAND licensing. So, our committee is, as mentioned before, the AIPPI's leading standing committee and only standing committee on the topic of standards and patents, meaning that we discuss subject matters such as SEP frequently on an international basis. And we have, apart from webinars, also in-person events such as panel discussions, the latest one having been just at the beginning of the month in our midterm meeting in Marrakesh. And I'm always looking forward to meeting everyone joining today in person there and hopefully also at our next in-person event, for example, in Hamburg or another AIPPI World Congress or midterm meeting. Before introducing myself and the speakers, let me just quickly go through some housekeeping items. So this webinar will be recorded. You can find it later on as well on AIPPI's YouTube channel. In order for the webinar to be orderly conducted, please also keep your microphone on mute. If you have any questions, and we would be happy for your questions, and hopefully we can answer many of them, please submit them in the Q&A box, which you will find on the lower half of your, or on the low end of your screen. For technical problems, please also send a message in the chat box to AIPPI events. And there will be a brief survey after the webinar. Your feedback would be very welcome because then we can, of course, adjust how we conduct these webinars and also make it a much more helpful experience for you the next time. So let me quickly introduce the panel today. So apart from me, I'm the moderator, Niclas Gajeck, patent litigator in Germany and before the UPC. And in private practice, of course, we have today as speaker Clemens Heusch, who is head of IP litigation at Nokia, and probably needs no introduction because he's very well known throughout AIPPI and the SEP space in general, as well as Elisabeth Opie, of course, who is the founder of Opie IP and accredited mediator in Australia, as well as licensed in Germany as well to practice. So, just as a general disclaimer, since this is also being recorded, please note that the speaker will only be presenting their personal views. They're not speaking on behalf of any clients, employers, or any other third parties. And that brings us right into the topic. So we will have overall structure. We will have a very, very brief introduction in the topic, starting with this slide, then to other slides, and then we'll head into the discussion with our speakers to make most of the time that we have. So just for setting the theme, presuming you all know what standard essential patents are, the overall item of interim licenses, of course, depends on the very big general issue that there is not one court who can exclusively, with the agreement of all other courts, set a rate for standard essential patents without interfering to some extent, at least potentially, with the jurisdiction of other courts. So patent licenses are typically global in scope, and there is no central venue to decide on the terms of such licenses. So we have a case-by-case question, which court is competent, and each court usually assumes a broad jurisdiction for setting or discussing or considering also in the context of injunctions the validity of a specific, for example, license offer and rate in the context of SEP licensing. And this brings us to the basic issue which gave rise to anti-suit injunctions, anti-suit injunctions, having been courts deciding on a FRAND rate, trying to prevent other courts from issuing injunctions in related disputes. So this goes back, for example, to disputes such as the US Ninth Federal Circuit's decision in Microsoft versus Motorola in 2012, where the US court assumed or handed out an anti-suit injunction, so forbid the parties, this case the implementer from the patent holder from enforcing or seeking an injunction, for example, in courts such as Germany's, as long as a dispute pertaining to a solution of the global license issue was pending before itself. So the underlying idea between these anti-suit injunctions always was there could be one court could resolve the whole licensing dispute on a global level by handing out a decision on what is FRAND, right? And for that reason, for this practical reason, it was assumed that the parties should not seek injunctions or other decisions relating to this global licensing dispute in other courts. And this, of course, was not well received with other courts, and we have seen that this for many years now, that even jurisdictions who have been traditionally hesitant to intervene with other jurisdictions and with the jurisdiction of other courts in other countries, such as Germany, have then started reacting by granting anti-suit injunctions or anti-enforcement injunctions. For example, in Nokia versus Continental in 2019, Interdigital versus Xiaomi 2122, under what is basically a self-defense doctrine. So the underlying idea was in order to protect my jurisdiction to decide, for example, an infringement dispute that might end with the rendering of an injunction for patent infringement, I would then prevent the other party. So, for example, an implementer or could even be a patent holder in some constellations that is suing for a rate-setting proceedings in another country from continuing these proceedings or enforcing any decision on a rate or any other decision for that matter that would prevent the German, European, the court deciding on the anti-suit injunction from then also rendering a decision on the merits. So, and how does that translate to our to today's topic, interim licenses and anti-interim license injunctions? Well, we have the same central issue. We have a global licensing dispute. We have no central venue that can decide on the terms of such license. We have disputes pertaining to the validity and to the question of infringement of patents in the various territories where these patents are enforced. And we have the issue that comity, so that the courts between themselves are not able to sort out the overall jurisdictional questions to an extent that would then allow them to render decisions limited to their territory, right? So we're always having, for example, decision on global FRAND rates, not on territorially limited ones. And interim licenses were a next step in trying to limit the dispute to being litigated before one court. And that was the court that was tasked with deciding on a global FRAND rate. Very practically, the UK courts have started granting declarations that a willing licensor would enter into an interim license regarding patents essential to an STO standard, pending determination by the patent court of what final license terms would be FRAND for the licensor's portfolio. So what we, for example, have seen by the UK High Court in Xiaomi versus Panasonic was the general finding that they might be willing to protect and could protect by issuing a license which would give the implementer a right to use for the time period between um, what is, for example, the start or the beginning of the UK FRAND license rate setting proceedings and the end of these proceedings, which could then presumably result in a global FRAND license rate or global license rate that the parties might then agree to. So depending on the finding by the UK court. And this interim license, so this right to use that is limited to the period of the UK proceedings, would then, of course, prevent a finding of infringement in other countries, as there would be no infringement as long as a license is enforced. So this has not been received well either by the German courts or the UPC, and we have seen at the third and fourth quarter of last year, so just very recently, for example, anti-interim license injunctions being rendered by both German courts and the UPC. And these anti-interim license injunctions basically do the same compared to anti-suit injunctions in that they prevent the party who was trying to limit the dispute from being litigated in a country where rate setting is taking place, such as the UK, from pursuing these measures that would then prevent at the same time litigation of infringement disputes in other jurisdictions such as Germany or the UPC. And to make it very, very easy to understand, the anti-interim license injunction would then state, for example, that the implementer seeking a FRAND rate in the UK is not allowed to pursue the interim license injunction. It's not able, may not further request the grant of an interim license injunction, interim license, sorry, or may not enforce an interim license, so to speak. So if there are specific terms provided already, then they wouldn't be able to ask the other party to agree to them, presume. So it really also depends on the case-by-case situation. But in general, the overall aim is always to maintain the respective court's jurisdiction. So, and what does that reflect to in terms of comity? We've already mentioned that term before. So, the level on which courts on an international scale try to harmonize their own jurisdictional capacities and potential conflicts with each other. So we've actually seen the standard of comity becoming maybe a little bit rougher over the last decade or so, or 15 years. So it started with the US 9th Federal Circuit basically stating that they are handing out anti-suit injunctions, but they are only doing it so if the disputes being litigated in other countries are vexatious. So in a sense, preventing an abuse was the original argument, and that argument has been then responded with, so to speak, by continental courts such as the Higher Regional Court Munich, with the argument that the anti-suit injunction is actually an attack on property rights. So the justification for every following measure, such as the anti-suit injunction, and later on, to a similar extent, also the anti-interim license injunction, has been that these are needed as a necessary self-defense mechanism to protect the local court's jurisdiction, competence, and also, of course, the rights to legal protection of the respective parties before the local court. And yeah, time and again, we have seen this conflict. And it brings us to some very, very interesting questions that we are hoping to discuss today. So without further ado, let's maybe look into, as a starting question, the point how much room there actually remains for an interim license being rendered in light of the decisions that we have seen in Germany and at the UPC. I think this is something that both Elisabeth and Clemens can comment on in much detail. Oh. And we're going into the discussion right now. So maybe Clemens, do you want to start on that note?
Yes, happy to start. I think we have to thank you slide again. So please stay with us for a little bit. Thanks, Niclas, for this introduction. Yeah, the nature of the so-called interim license is indeed quite interesting. I mean, I looked into various civil law acts, and I did not find in any civil law act, the German BGB or other ones, something like an interim license. So what is in the end the nature of that? I think the interim license is the attempt to make a provisional ruling until there is a final ruling. And why? I mean, the idea obviously is that you say, okay, we grant the implementer an interim license. A short-term license is also a term we heard, so that he can raise as a defense in all other courts in the world that he is licensed, so therefore there is no infringement, no claim for an injunction, and while the UK court, for example, can continue with its rate setting case. The question then, of course, is if there is no legal basis for that, how can this be justified? Are they entitled to do so? In the Ericsson versus Lenovo case, the UK court itself found, rightly as I believe, that there is no court in the world which has international jurisdiction to set a global rate. And I think the European Commission in the WTO case versus China brought it quite clear on the point when they asked the question, why does a Chinese court believe they are competent to set a rate for the use of a European patent in Europe? And that's a little bit the same now with the interim license. So UK courts as a starting point don't have jurisdiction to set a global rate, and this also then means logically that they also don't have jurisdiction to set an interim license. What they said in the Ericsson-Lenovo decision, that there's a gap, there is no clear international jurisdiction, so they need to fill the gap, and they made some commodity arguments who is best situated to fill that gap, to set an international rate, and then they concluded that, surprise, surprise, it is the UK court. And in order to protect their proceedings, they then also started making declarations on interim licenses. So far, the UK courts have always said it's only a declaration, what a reasonable licensor, in their opinion, would do. The reasonable licensor would not continue infringement actions around the world while the UK court is determining a global rate. The problem is that the UK court apparently does not care about whether the patent owner ever agreed to that court. I mean, there's probably no doubt if two parties agree that a certain court should set a rate, then that court has jurisdiction. Like, for example, in the Panasonic versus Xiaomi and Oppo case, here both sides have agreed to a rate setting by the UK court. But what is the case if one party does not agree? Do they still have jurisdiction? I think the English judges are probably the only one who assume that there's jurisdiction. But I think that's wrong. But on the effect, again, so far they only said it's a declaration, what a willing licensor would do. The question is, what is the consequence? So first of all, if the licensor follows, the patent owner follows and offers such an interim license, then we are good. Then he has, in the end, done so maybe more or less voluntarily, and there's a license and there's a rate setting case, and we have a scheme. But just assume that the licensor says, no, I don't want the UK court to set a rate. Maybe I consider them not competent or implementer friendly or whatever, or I just don't want that. What happens then? So he will not accept the UK jurisdiction. He will also not offer such an interim license. Is then there a possibility that the UK court could use any court order to make the patent owner offering such a license. So far, it has not happened, and I heard from many judges that it will never happen. But I wouldn't fully trust. Here we have also heard UK courts just 1 year ago saying in the Panasonic and Xiaomi and Oppo case that they only granted the declaration because both sides have committed to a UK FRAND setting. And as we all know, just a few months later, they did not remember this important point anymore. So therefore, yeah, I said the case law is moving quickly, and I think nobody at the moment knows what comes next. The other interesting question is, if they make a declaration that what a reasonable licensor would do is offering an interim license, what is then the effect just of that declaration? I think that is so far quite open. I heard several voices from non-UK judges that they would not consider this declaration. They said we have ourselves the tools and the empowerment to decide whether there's a willing licensee or a willing licensor. Thank you very much, UK, but we don't need this guidance. So therefore, I think just the declaration will probably not help the implementer in other courts to be considered a willing licensee or the patent owner to be an unwilling licensor. But also that is so far undecided. There were some, at least obiter dicta or remarks in decisions by continental European courts, but I'm not aware of final decision in that regard so far.
Elisabeth, we've already heard that the courts, they're of course not enjoining each other, but they are enjoining the parties. From a more of a common law perspective, what do you think can the UK courts still do, or would they still do in the interest of the parties if they still think that the interim license instrument is a practical one?
Excuse me, I agree with Clemens. What's being granted here is a declaration, so it's not an order of the court, and indeed it could not be an order of the court that the parties enter into a what's called an interim license. I can quickly just give an overview. I'm also a qualified English lawyer, so I've got a practice English law as well. Go back to the origin of where did this concept first arise? So it was in the 2024 Xiaomi against Panasonic proceedings, or that's when the decision was handed down. With Xiaomi as part of an overall proceeding. There'd been proceedings initiated in the UK, also Germany, and they'd applied for a declaration that a willing licensor in the shoes of Panasonic would enter into an interim license. It's related to 3G, 4G patents, pending determination by the Patent Court of FRAND terms. And as Clemens has already pointed out, both parties had given an undertaking that they would be bound by such a decision or determination. At first instance, Justice Leach, he did not identify a useful purpose for making such a declaration, as it would only be to influence the German proceedings, what he called an exercise of jurisdictional imperialism. And from that, Xiaomi appealed. The High Court, so what is the basis of even asking for such a declaration? The High Court does have inherent jurisdiction to grant a declaration. So this is Rule 4020 under the Civil Procedure Rules. And there's a couple of key considerations. So one is that it would serve a useful purpose to do so. It must not only be useful, it also has to be legitimate. So the discretion is not an unfettered one, meaning that its exercise is not dependent upon claimant satisfying any threshold, or in addition, for the scope of or the threshold for applying. There's no particular threshold. It has also been observed that it is not appropriate for an English court to be making a declaration for the sole purpose of influencing a foreign court's decision on an issue governed by the law of that foreign court. On appeal in Xiaomi against Panasonic, the Court of Appeal did hold that a useful purpose would be served in this case to grant the declaration, and it considered that comity was not a reason to deny the grant of the declaration subject to modification of the terms of the interim licence. That decision was a majority decision. So the dissenting judge, Lord Justice Phillips, did not agree that a final declaration or declaration should be made prior to the FRAND determination by the Patent Court, as there was no basis for an interim FRAND. Rather, he considered that an ASI, anti-suit injunction, could be granted in these particular circumstances. Clemens already given a couple of highlights from a couple of subsequent cases, Lenovo against Ericsson, where Ericsson challenged the jurisdiction of the court. This was in the case of a cross-license negotiation. There's been the Alcatel-Lucent against Amazon, Samsung against ZTE. I'll note that in Samsung against ZTE, the court considered the grant of the declaration would serve a useful purpose in that case because it would be persuasive, albeit not coercive. So indicating that the courts are aware that the granting of such declarations will have some kind of influence about how the parties will proceed from there on. I guess the latest case, so far as I'm aware, is the case of TP-Link against Huawei, where it was actually the licensor that approached the court for the grant of a declaration that a willing licensee would be entering into an interim license. So we've seen it applied both by licensors, potential licensees. Where to from here? It is really, going back to your original question, actually, Niclas, following what's been happening most recently, I think in particular in relation to the InterDigital Amazon proceedings that are on foot in the UK, Germany, UPC level, how much room remains for there to be an interim licence to be applied for without risking an AI ally? On that question, I would say every case is case dependent. So you've got to look at the totality of the circumstances, even for the application, whether it be for the grant of a declaration or for the grant of what's now called a ALI or AILI. The other thing that I would note at this stage is that the concept of an interim licence is not something, so far as I'm aware, that is recognised in any other jurisdiction, nor something that the market actually practices. Because, as you noted, Niclas, if you're granting an interim licence, effectively it's a licence. And maybe it's subject to some huge proviso that maybe there's something ahead that will impact where we eventually or finally land. But it appears a significant challenge to have such a concept fitting within the framework of, as I said, what's happening in the market, the current legal framework, and also, the TRIPS agreement certainly doesn't accommodate for such a concept. Thank you.
Yes, thank you. That's very, very helpful already. And we've already touched upon the second point. So we've established the interim licenses granted so far, if you can call them that, are mostly declaratory in nature, right? So, and in the most prominent and first case, there was actually agreement between the parties to have this declaration made by the court. So if it stays on that level, what could the consequences possibly be? Do you think it would have a substantive, for example, input on the decision whether the licensees or licensors' behavior is willing, both in the UK and in other proceedings? Already established that the European courts, continental courts, UPC, the German courts, they might make up their own mind on it. So do you think the fact that a party, let's say it's in a non-consensual way, applies for an interim license in the UK could then be turned on its head and be actually a factor to consider that party unwilling to agree on a FRAND license by other courts. Is that something, Clemens, Elisabeth?
Yeah, I'm happy to go first here. There have already been some indications, especially from the Munich court, but also from other courts, that kind of these attempts to block existing cases or influence existing cases can be considered as unwillingness by the licensee. I mean, the point is, the patent owner has an exclusive right. He has a patent which he tries to enforce in the jurisdiction where the patent is validated, where the patent is granted. So far, so good. Then what do, for example, the UPC or German courts do? They look, is the patent infringed? Is it valid? So at least on a high level when they decide on whether to stay the case or not. And then, of course, like in every normal civil procedure, you look, are there objections? Objections, as I mentioned earlier, can be the defendant is licensed, but it can also be the so-called FRAND or competition law objection. He has a claim to a license and he didn't get this license, the famous FRAND objection. So here, I think all arguments will be heard, and then starting a rate setting case elsewhere is in the end an interference, because the defendant wants to tell the German court, look here, that is the license I should be getting, and I didn't get it, and so therefore you shouldn't injunct me. That is, I think, the entire attempt of this rate setting abroad. And then we have the big problem, timing, because we all know that especially the Munich court, but also other German courts, Dutch courts, Brazilian courts can be very fast. And so that a UK ruling might be too late. And I've also been several times in UK hearings where there were requests to expedite the hearing. And then the entire argument, and Germans are surprised to hear that, but they can have one full day hearings just to decide on whether the hearing should be expedited or not. And there really the main point of argument is, do German courts, do UPC need help from the UK court to get things right? And I think everybody can imagine that a judge is not too excited to hear about this and considers this rather an interference than really guidance. Yeah, coming back to your question, I think that probably courts in Germany or at the UPC or other continental European courts don't need that guidance, and they don't even consider this helpful. And therefore, I think it is maybe, at least in these courts, rather damaging than supportive.
And Elisabeth, maybe then the other way around, how would the UK court reflect on, for example, an anti-interim license injunction request being made by one of the parties in a continental court?
It's again, it's dependent on so many factors, and what's happening in that particular case. In the UK, the courts are looking at these licensing disputes as based on contract law rather than competition law. That consequence of that is that they're not really looking at the conduct of the parties, whereas in Germany, in Europe, one would be looking at the conduct of the parties, and in particular the length of time taken, for example, to respond to an offer, etc. Not only of the potential licensee, also of the licensor, whether or not the offer is on its face FRAND, or whether an offer was made and particular information was provided, trying to stymie a negotiation rather. So it's not a binary, yes, it would have impact, no, it wouldn't. You'd really have to be assessing what's been going on, where are other proceedings taking place, do they have precedence to whatever is happening in the UK. Sorry, I can't offer more than that.
No, that's perfectly fine. I think we What we've seen so far is really that it is very case dependent, as you already said. And that, of course, brings us to the question if there are not other instances that could then resolve the dispute more efficiently. So if it's really case by case, would, for example, arbitration or mediation be a solution? How do you think have the respective entities fared so far? So have you seen a lot of arbitration mediation in the field? And do you think that might change also with the, for example, UPC's new patent and mediation arbitration center that's going into operation soon?
I'm happy to go first here, Clemens.
Yeah, sure. Since you're the mediator, please start.
Thank you very much for this question, Niclas, because I think it's very important to understand the context for this discussion. And I will not assume that the licensing around standards is broken, because it's not. The vast majority of licenses are put in place through negotiation, and it's a relatively small number of cases where the parties are not in agreement on license terms. And quite legitimately are seeking third-party assistance. Where infringement is alleged, I think it's wholly legitimate to protect one's IP rights through the initiation of infringement proceedings. And in fact, failure to do that might actually impact upon further enforcement or even licensing rights and revenue moving forward. I think Huawei against ZTE is a case that acknowledged that parties to a patent licensing negotiation regarding a standard implementation can, by common agreement, request that the amount of royalty, and that's normally what is in dispute, can be determined by an independent third party. So having extra fora created, such as the UPC's PMAC, is welcome to the many other offerings that we have globally for arbitration and mediation. Just in relation to the proposed SEP regulation, I guess for that there was no final conclusion to what was proposed, and there was still quite a lot of discussion on what could be included in the proposal, alongside the discussion of possibly including new institutions to become involved in the area of patents. So no final position, so far as I'm aware, was put forward by the Council of the European Union. Trilogue certainly hadn't commenced, so it was still far off a finally agreed text, as I understand it. That proposal has been withdrawn in its entirety, although by majority vote of a subcommittee in the EU Parliament, who voiced its, how would you say it? They did not agree with the withdrawal. There's now proceedings on foot in the CJEU on the action of withdrawal. As I said, I think that anything that can be done to assist the parties to land on an agreement is a good thing. Having said that, it really lies with the parties to be making good faith efforts and to be acting without undue delay to actually finalise an agreement. So it's the exchange of information that's really important between them, so that kind of quoting from Huawei against ZTE, so that there's sufficient exchange of information so that a good faith negotiation, arm's length negotiation, can take place between them. I think you can have a million new things created to facilitate, but it ultimately comes down to the particular parties.
Yes, that's an interesting point. Probably, Clemens, you also have a lot of in-house perspectives on the SEP regulation in particular. For example, there was a mechanism in there that could have helped both with getting more information to the parties, right? And another mechanism that would have probably, in a sense, established a mandatory scheme of negotiations before the proceedings. Do you think that if that had come to fruition, if that had become real for the parties, would that have changed also the European litigation market? Would have parties then sought other venues, India, China, Brazil, for example?
Yeah, so first of all, I'm happy that the SEP regulation, which I consider it really a bureaucracy monster, which would have created enormous costs for both sides. I'm happy that this is off the table. Yes, Elisabeth is of course right. The parliament or the parliament has sued the commission for dropping the initiative, and this now touches, let's say, fundamental questions about the separation of power and who in this in the EU can do what. But okay, for now it's off the table. And even if it should sometimes in some form come back, it's still a long, long way to pass the council. And I understand that the commission has discontinued that initiative because they did not see any chance to get any version which is capable of getting a majority in the council. That was in the end the reason. And I think that hasn't changed no matter how the CJEU will decide one day. No, but I think you touch a very important point, that is the transparency. Some level of transparency is definitely needed. The problem with the transparency is you also have, let's say, early licensees who don't have dozens or hundreds of comparables they can look at. They do an economic evaluation. What is the value of the technology? What am I willing to pay? And they come to agreements. So there must apparently also be some ways to conclude agreements with limited transparency. And what we as when we are licensors see quite often is that there are just a few companies who all hold out very long. So they ask for more, and they want to see this, they want to see that. And then at the very end, they want, of course, to get the very, very best treatment. So I take the duration, the term of that contract, and I take the rate of that contract, and I take the past release of that contract. And I think that's maybe also not a fair approach. So therefore, I'm not sure how much transparency is necessary and really helps at the end of the day. And how can we avoid that we give incentives for hold out and for delay tactics? So therefore, let's say transparency is definitely important to some degree, but it also doesn't help to solve all problems. What is, in my view, most important is that you have reasonable people on both sides who talk to each other, and you always have to talk to each other. Otherwise, you will not find a solution. And I'm doing my job now since quite a while, and every single case so far has at one point of time come to a settlement between the parties. Because if you get, for example, an injunction in Germany, in the UPC, even if you enforce it, this doesn't solve the case. And it also doesn't mean that the implementer then immediately signs the license offer, even if the court says that is a FRAND license offer and no objections here. It doesn't solve the case. And the same is true the other way around. If we have a rate being set by a UK court, by a Chinese court, or by a court in Kenya or Timbuktu, this will also not solve the case, because at least one side will say probably that they are not satisfied with the rate. They, for whatever reasons, don't agree with that. They will not make such an offer, or they will not accept such an offer. So I think all the courts can give some guidance. They can help the parties to better understand where they are standing, where they have weaknesses, where they have strengths. But at the end of the day, the parties need to come together and to talk to each other. And now when we speak about alternative dispute resolution, mediation can be here very helpful. Sometimes it's also an internal decision making. Let's just assume, for example, the licensor makes an offer and the licensee believes maybe it's not completely out of scope, but my management will kill me if I propose to accept that offer. If I have a mediator who says, I've seen so many contracts, I've checked everything, this seems to me like a reasonable offer, might help the decision making. Also, another advantage is that a mediator sometimes does have more information than the parties, or that the parties make information available to the mediator. So here are upsides. And then the biggest upside from my point of view is that in a mediation, you can just do other things than just say exchanging numbers. For example, if we want to conclude a license agreement and we cannot agree on the numbers, the mediator can make proposals which you will not find in a judgment. How about you, whatever, accept some kind of midpoint, but therefore you also buy some products, you transfer some patents, you do some collaboration, whatever. These are ways to bridge the gap which exists in a mediation, where a court usually cannot help you. if it really comes just to put the price tag on this. At Nokia, we believe that arbitration is a good way to do that, just because it is a court or an institution where both sides have to agree to, and then there's no question about competence, about jurisdiction. So that is then a legitimate court if both sides agree to that. But also you have experts. Both sides can choose one arbitrator. Usually there are different rules and different mechanisms, but usually both sides can choose one arbitrator, a person where they think, which they consider as really competent, as really good to solve the case. They together look for a chair. So there you can have a lot of competence in the room. And we have done this several times, having FRAND arbitrations, and it works. And it is, let's say, all in one track. You have no injunction risk, you have no invalidation risk, you have a quite predictable budget, a quite predictable timeline. So there's a number of reasons why arbitration makes sense. Surprisingly, also from my point of view, is that implementers seem not to like arbitration. Maybe they don't want to they don't want to be bound by that. They consider the risks too high, that they get an outcome they don't like for whatever reasons. So therefore, I see quite often that patent owners are offering arbitrations and implementers are rather refusing it. But they do take place, and it's a, I think, legitimate way.
So does the interim license, developments around interim licenses, do they provide any positive net effects to that? Do you think they can actually make, for example, licensing negotiations more productive because there is also a work stream at the court? Or do you think it will simply end up in a jurisdictional gridlock?
Elisabeth, you want to go first?
Sure. I guess the intention of a declaration about a licensor or a licensee willingness is to get the parties to the bargaining table. We've seen in the UK there's been very different outcomes. So Xiaomi against Panasonic, they ended up settling. We don't know how much the impact the making of the declaration had. There was obviously a lot of other things going on behind the scenes. In Lenovo Ericsson, I don't know that it made any difference on the face of it. Maybe not. So it's really hard to say, well, what would be the KPI for keeping such, key performance indicator for keeping such declarations happening. Because you can't tie it down. It's not. I wouldn't call it a silver bullet solution. I wouldn't call anything a silver bullet solution. If we looking at the intention of this is to somehow operate independently of comity, where parallel proceedings are on foot in other jurisdictions, and the intention is to influence those. So I think that could be challenging well, we've got this concept of comity, so how do we respect that? And it won't be the same answer in every jurisdiction. We can see, from cases in Germany, there are, or UPC, there's reasons why interim license concept isn't recognised, but also why national courts want to keep national jurisdiction. It's because of the legal framework, and they're effectively mandated to do so in certain circumstances. So there's those kind of considerations. What we have seen as a consequence of, the declarations and AIPPI being kind of the response to that, or the application for those, is that there has been a notification to the European Commission, DG Trade, about orders of the UPC, Unified Patent Court, and what is happening in the UK for the interdigital Amazon proceedings. So it's yet to be seen if there's anything that might happen through those channels as well.
So maybe to bring it really down to a point, do you think the whole developments around interim licenses in the UK are actually a helpful development that will bring negotiations forward, or do you think parties might be better off putting their efforts, for example, into arbitration mediation at the venues such as the UPC's PMAC in comparison? So which basket would you put your coins in, depending on whether you're implementer or patent holder or both?
I so far haven't seen anybody to whom the interim license declaration was really helpful. I mean, we have seen that the Ericsson versus Lenovo case settled quickly thereafter. We don't know whether it would have settled anyway or what was the driver here. I personally, with my academic heart, was sad to see that, because I would have loved to see what would have happened next. How maybe even the Supreme Court would have decided, but well, now it needs other parties to take it there. But otherwise, what has been achieved through the interim license so far? We haven't seen that any German case, UPC case, was dismissed or so because of the interim license. It produces a lot of costs, like every hearing in the UK. I think we all know that every hearing day in the UK is a nice 5-digit amount or so, which is easily spent there. You can take a lot of licenses with that money, but so therefore I haven't really seen the upside. Then, if you just a little secret, if you agree on an arbitration, you have something quite similar to an interim license without a big hearing, without an extra payment, because usually arbitration agreements would include that you bring all other litigation to a stop. And this means then, that you kind of have something like an interim license. You can freely act on the market while the rate is being determined by the tribunal. So therefore here it works somehow. Yeah, but otherwise, the interim license, or the so-called interim license, I think it is interesting to see, for example, how it has been turned around in the Huawei versus TP-Link case, because here they really did it the other way around. That here it was the patent owner who said, okay, let's do the UK rate setting. And here, coming back to my earlier point, then you have an agreement by both sides. So then both sides agree that the UK court should set the rate, and that's perfectly fine. The UK court, no doubt, is capable to do that and is willing to do that. And if both parties say, yes, let's have the UK court setting the rate, then that is fine. And here, then Huawei asked for an interim license, and TP-Link, from what I've read, was then arguing that it should be a relatively low amount, which is to be paid in the interim. And I think it was Justice Mead who then said, no, I stick to our case law. We take the midpoint unless we have very strong arguments why the midpoint is roughly wrong. And then TP-Link was suddenly surprised how much money they have to deposit. And if you have to deposit a very significant amount of money, then this can, of course, also, let's say, offer or open some settlement opportunities, because then the money is somehow out of your pocket or blocked or so, not available for operations. And this can be a driver to then initiate settlement talks. And so maybe in that regard, an interim license can be useful, but that is still pending. So we will see how this case develops.
Elisabeth, anything to add on that?
No.
I think we're already broadening the scope of the discussion, so to speak, because we're touching upon the requirements of a willing licensee, so to speak, right? How much security in terms of bond do they have to provide during the negotiations? How much do they maybe even have to pay upfront? We've seen new precedent from German courts on that as well. So,
if I can make an interesting comment here on the latest developments of the German case law. So we have seen some cases in the past where the German courts considered the implementer to be unwilling because they did not engage enough into the negotiations. And that is definitely in line with the Huawei ZTE case, where it says several times, without delay, and so on within usual business practice. So holding out for years and delaying and not answering and asking for more and more and more information, which you can easily find yourself, that is unwilling. And so therefore not giving a FRAND defense seems fine to me. However, the downside is that that this gets criticized in other jurisdictions. They say you injunct implementers without ever having looked, is there a FRAND license available? And so therefore I see the development that this has now changed. I had myself a case in Munich a few weeks ago, 2 or 3 weeks ago, where the court then really said they are unwilling, or at least there's a likelihood that they're unwilling, but we don't stop here. We really look in depth in all the 93, I think in this case was the number, 93 comparables. And then it sets positively in the judgment the offer by the plaintiff is FRAND. And I think that is a new development, which I think is a very fortunate development, which helps also for the recognition of German judgments abroad. But the point I wanted to make here was quite interesting, because in that case, the implementer also requested an interim license from the UK, and the Munich court said the patent owner is not bound by that because they didn't agree to that proceedings, but the implementer is bound by that. So if they want to be a willing licensee, then they have to deposit the amount which is set by the UK court, which in this case the parties did not do, and therefore they were considered unwilling. So therefore, be careful what you wish for. It can really hit back.
It's almost perfect finishing words, I would say. But of course, we're also open to any questions from the audience if there are any further items. Without broadening the scope too much, because I think we're already indulging other topics almost, going into the details of willingness, unwillingness, and the most recent developments on bonds. And
it's all somehow related to each other. It's probably difficult to discuss the one without the other.
It is.
Yeah. One point I would like to mention, it has been mentioned already, the cost element. So for every additional procedure or additional hurdle, it's costs, and it really starts getting away from commercial arrangements and could eventually make a deal non-commercial. How much do you have to pay to actually get a license in place and be getting the revenue, even if interest is payable for past practice? One thing that I've seen in the US case law is that expert evidence can be submitted in court in order to provide testimony as to whether there's been a hypothetical increase or decrease in royalties when considering the case in which licenses can be concluded, with or without litigation, and also consider whether there's been a challenge to the validity of patents. And this happened in a case going back a few years ago now, but it was St. Lawrence against ZTE. And the court essentially held that a litigated rate is higher than a FRAND rate. So that hasn't translated as yet, I don't think, across the pond to either the UK or Europe, but the cost to the parties, hopefully that's a consideration for the exercise of any jurisdiction.
Yeah,
definitely. It comes down to the pleadings of the parties, I know, and the conduct of the parties.
Yeah, cost is definitely an issue. And I mean, not every case is 100 or million or 500 million case. There are also license agreements that say with a value below 1 million, and then you don't want to spend 30 million pounds for a UK rate setting case. So I think that's also something to keep in mind.
Maybe before we close it off, we actually have 2 more questions from the audience. And the first one, I think, Clemens, you already touched about that, is in certain scenarios of extreme holdout. Could in those scenarios interim license declarations and deposits be welcomed by SEP holders, so by the patent owner?
Yeah, that's a good question. I read that already. I think if there's extreme holdout and you don't want to conclude a license agreement, then you really want this company out of the market. That's unfair if others are paying and that one is not paying. So therefore, I think then I would prefer really a straight injunction, but you can, of course, come back to the market by taking a license, but then, of course, also covering the past.
And then maybe to conclude the last question, which is a relatively broad one, by Stephen Van Dyke. Are there any worthwhile specific deviations or dissenting viewpoints as applied by the UPC when compared to the national courts, such as the UK and the DE court? So comparison UPC perspective, UK and German perspective. If you want to touch on that, Elisabeth and Clemens. I think we broadly discussed the UK perspective on the one side and the UK and the UPC and German perspective on the other, right?
Yeah, I think so far we have not seen many SEP decisions from the UPC. The ones, yeah, as mentioned, for example, Panasonic versus Oppo, that was definitely not kind of copy paste of German case law, but maybe a little closer to the German case law than especially to the UK case law. Other cases, there was one pending in Portugal, which I think didn't get to these points. Others are pending in the Netherlands. I think here we still have to see a little bit how the UPC generally is deciding. But so far, I think, yeah, they were quite a contrast to the UK and maybe a little closer to German case law. But as I said, it's maybe too early to draw general conclusions here.
Elisabeth, do you agree?
Yeah, I share those observations.
Yeah, wonderful. I would then bring this webinar to an end. Thank you so much, both Elisabeth and Clemens. We got a couple more questions in the chat, but unless you may have a short look, unless you want to answer any of them in particular with view to the time, I would say we're happy to answer any follow-up questions per email as well.
Yes, maybe easier by email since time is really running up and the questions especially are too complicated to answer in one sentence.
Definitely. So thank you so much for sharing your knowledge with us. And as to the audience, thank you so much for attending, for spending your time with us today. And yeah, we want to inform you also of the next webinar, AIPPI webinar that is coming up. We have a cultural heritage themed webinar topic, protection of cultural heritage, right of misappropriation, community rights, and sustainability on the 26th March. Registration will open soon. Please attend. And then, of course, please also attend AIPPI Germany's World Congress, so the global AIPPI World Congress, this time featuring the wonderful city of Hamburg. And the hosting group will be AIPPI Germany, of course, 7th through 10th October, right after German IP conference Ruhr. So if you can, make sure to attend, and hopefully we will see you there at the latest.
Thanks for the moderation. Thanks, everyone.
Yes, thank you.
Thank you.
See you.
Goodbye.